Do you want to turn now to a discussion about consecutive sentencing?
Yes.
Okay.
While the proposition deals primarily with third strike offenders, there are two areas of important change that relate to both second and third strike sentencing. And this concerns 667C and 1170.12a. It's also important to understand that this is the only area where there are not parallel changes. Most of the time, the enactors were very careful to create parallel changes in both 667A and 1170.12. This is one area, however, where that did not happen, and we have some issues with that. I think it's important to start with the basic law first. Section 667C and 1170.12a originally had three subparts, 6, 7, and 8. Subsection 6 dealt with multiple felonies of any type. If there was a multiple felony committed that was not on the same occasion or out of the same operative facts, the statute required that there be consecutive sentencing of those counts. Subdivision 7 dealt with just serious or violent offenses. And it also said that those offenses must be sentenced consecutively if they were not committed on the same occasion or out of the same operative facts, because Subdivision 7 referred to Subdivision 6. The Supreme Court, in the landmark case of People v. Hendricks, has tied these two sections together so that whether it's any felony or a serious or violent felony, mandatory consecutive sentencing only arises when those crimes were not committed on the same occasion or out of the same operative facts. Subdivision 8 deals with a situation where the defendant is already serving a term when being sentenced for the three strikes offense, and it directs that the third strike sentence, or the second or third strike sentence, be consecutive to that term. Now, this was the change made to 1170.12a7. They didn't change A6, so that has been left the way it was originally worded, and still deals with any felony committed in a situation where it was not on the same occasion or the same operative facts. It must be sentenced consecutively. Subdivision 7, however, was amended to drop the reference to subparagraph 6, and instead the section now simply refers to crimes listed as strikes. The net effect of that change now will affect the way you sentence on serious and violent felony offenses. Under the new law, serious and violent felony offenses must be sentenced consecutively, regardless of whether they were committed on the same occasion or out of the same operative facts or not. It doesn't matter. Any multiple serious violent felonies are to be sentenced consecutively. It seems pretty clear to us anyway that the intent was to abrogate Hendricks and to now make the crime fit for the serious and violent offenders be a longer term where you require this mandatory consecutive sentencing. It was consistent with the intent of the legislation to do that. The legislation also changed subparagraph 8, 1170.12a8. It simply deleted that provision altogether. Which means then the net effect of that change is that now courts have the ability to sentence concurrently the crimes that are not serious or violent. You have to kind of read the lack of 8 together with existing 7 because existing 7 says that you must sentence serious or violent felonies essentially anytime you can do it, you must do it. And that, of course, would include terms otherwise serving, the defendant is already serving. But as to the non-serious, non-violent felonies that are sentenced under the three strikes law, those sentences now can be run concurrently with the elimination of Section 8, can be run concurrently with terms already being served. Here's the problem. The conflict is that these changes were made to 1170.12, but were not made to Section 667. So we have now two statutes that are dealing with the same subject in exactly opposite means. Is this a drafting error? Most likely. They simply did not pick up the fact that that law existed in both statutes. It was not changed. The question, of course, now is what to do about it. In our materials, you'll find a reference to a case called People versus Garcia. And there the court talks about the process for dealing with these kinds of conflicts that appear to be related to drafting area. You look at the intent of the legislation. The ballot statement really is a goldmine of this, and it makes clear that as to dangerous and violent offenders, they still wanted to have the long sentences, the full 3 strikes operation. These are dangerous and violent people that need to be kept off the streets, so the long terms apply. And by the same token, as to the non-serious, non-violent offenses, they wanted shorter prison terms, more in the line of a 2nd strike sentence. These 2 aspects of legislative intent are consistent with the changes made under Section 1170.12, both as to 7 and 8. Those changes seem to be perfectly consistent with that intent. So I think if you apply Garcia, if you are convinced that that is the proper method of analysis, I think you can essentially read 667 now in the same manner as 1170.12. There may be a situation, however, where district attorneys may be tempted to charge the statute that they like for that particular circumstance.
Probably the one that will result in the longest sentence for prosecutors.
I would guess there'd be no surprise to
yes.
that. The question is, can they do it? We think there's going to be a major equal protection problem there, and that they just simply can't pick and choose what statute to sentence under.